Hello and welcome to Child Custody University, Module 3, Evidence That Matters. Why prioritize evidence? Custody cases are full of accusations. These accusations can be denied with a swipe of a pen. When these accusations are supported by evidence, they can become facts for the court's consideration. Every litigant needs to understand all about evidence. Even if you have an attorney, you need to know this. Even if no one has filed any papers yet, you need to know about evidence. It is never too soon to start identifying, collecting, and preserving evidence. Evidence is most helpful when it supports a conclusion that other evidence also supports or even alludes to. There are times that you have evidence that you might not realize supports the opposition's argument. All evidence must be considered in the context of a trial, as well as from the position of neutrality, and not just from one perspective. The evidence needs to be scrutinized from all perspectives. Your credibility is very important, and evidence can make or break your case and your credibility. When you consider the cost and consequences of a trial, evidence is a game changer. Even if you never see a courtroom, the evidence has great value in negotiations. The time in front of a judge is minimal. Your child's future is invaluable. Take it seriously. Your children are counting on you. The more you prepare for a trial, the less likely you will see the courtroom, because your negotiating position will be stronger. The best scenario is to negotiate a settlement from a position of power. It is common to equate law and a trial with the concept of fairness or righteousness. Courts serve equal justice under law. This is not necessarily fairness or healthy. The courts are short-sighted. They look backward and not forward with consideration of facts that can be supported by evidence, hopefully. Only subjects of trials will find themselves judged in this manner. Your sense of justice will be best served by coming to a settlement with the other party. Some type of mediation or collaborative process is always available, and sometimes mandated before a trial. The common block to a settlement is confusion, misinformation, and fear. Much of the conflict driving senseless trials are misunderstandings. A list of common misunderstandings follows. Please consider them in relation to evidence in your case, as well as negotiations. 1. Legal positions are confused with a set of values. 2. The opposing party misunderstands your position or point of conflict, or the opposite. 3. Solutions exist that neither of you is aware of. 4. Lack of perspective due to immaturity. A trial process is a bad way to grow up. 5. A parent's interest and the child's interest are not aligned. Counselors may help. 6. Emotional facts are not facts. 7. The solution in court may not be the best for your child. It is the only option given the conflict. 8. A judge cannot always make the decision they want. They are limited, and good evidence can open their options. Every parent would benefit with a clear understanding of what evidence is. Evidence is what the court will accept under the rules of evidence. It must be credible and not considered hearsay or privileged communication. The evidence must have probative value greater than a danger to unfair prejudice, confusion of the issues, or consideration of needless presentation of cumulative evidence, undue delay, or a waste of time. These are common evidentiary rules that apply to the bulk of legal proceedings. In an attempt to ascertain the best situation for a child, a judge in the family court may deem any evidence or testimony they find relevant to the litigation admissible. Basically, it needs to be relevant and impact the situation enough to impact the outcome. I offer you 5 prerequisites to keep in mind for evidence to be considered credible. 1. The item should have a logical connection to a fact of consequence and significant to the outcome of the case. 2. The item should tend to make a fact more probable than it would be without presenting it as evidence, and the fact is of consequence in determining the action. 3. The item must be supported with information that it is, in fact, authentically what the presenter of the evidence claims it to be. 4. Evidence must be true. Inventing or falsifying evidence is a crime. In certain circumstances, prosecution happens. 5. The creation or occurrence of the item should originate within a relevant time frame of the matters at hand. The family court may not consider a parent's lifestyle prior to the child's birth. It is important to note that there is a large legal difference in the words may not and shall not. May not expresses a possibility, and shall not expresses an obligation. Locating evidence is a skill. The most basic types are testimony, documents, and physical evidence. The sources of evidence are essentially limitless, but here are 7 common sources. 1. Fact witness. 2. Expert witness. 3. School or medical records. 4. In-camera child interview. 5. Photos, journals, videos. 6. Police or health and welfare reports. 7. Texts, emails, and audio recordings. That list of 7 items can be understood in greater depth by considering the collection and presentation for a trial. 1. A fact witness is a person who holds information they have first-hand knowledge of. At times, a deposition can take place formally and under oath. Have the witness testify prior to a trial for the purpose of establishing facts the witness might have, especially when they may be unpredictable. 2. An expert witness is a person who is qualified to offer an opinion and paid by one or sometimes both litigants. This is the only type of witness that testifies for their opinion. They often will not testify unless they are comfortable with the attorneys on both sides and the circumstances. Always use a subpoena for your expert witness, especially when the witness has interacted with both parties or may appear biased in your favor. 3. School and medical records can usually be obtained with a simple request. If that does not work, a subpoena should. If you use this evidence, it needs to make a specific and relevant point. 4. An in-camera interview is when the judge interviews the child or children in their chambers. A litigant can motion for this, or the court can order it. 5. Collecting photos, journals, and videos should be easy because you likely already have it. If not, you can subpoena whoever has them. Keep in mind that whatever it is, it needs to be relevant. To have these admitted into evidence, you must create a foundation for them. This will be discussed later. 6. If you have rights to the police records or health and welfare records, you will simply request them. If not, a subpoena may be effective depending on the circumstances. To have these admitted into evidence, you must create a foundation for them. This will be discussed later. 7. Texts, emails, and audio recordings you likely already have. If not, you can request or subpoena them if necessary. To have these admitted into evidence, you must create a foundation for them. This will be discussed later. A deposition, as mentioned earlier, is a formal questioning of a witness for the record. Interrogatories are a written version of the same process. They are often used strategically to be used at trial in an attempt at impeaching the witness. This is done sometimes by asking similar questions at both the deposition and the trial to elicit different responses and cause the witness to appear to answer inconsistently. The goal is to make the witness look like a liar and therefore be impeached. They are both tools intended to assist in the discovery process. The discovery process is a formal process of each side in a case exchanging evidence intended on being introduced at trial. Each side can and should file a motion for discovery and have it served on the other party as the official request for the records. It is also often a stimulant for productive settlement talks. This is because the strength of cases is often revealed at this point. The concept of burden of proof is relevant in this discussion of evidence. There are 2 levels in law. Beyond a reasonable doubt is in all the movies and related to criminal law. A preponderance of the evidence, or 51% convincing, is the threshold for civil cases like child custody. With your evidence, You want the most objective evidence you can find because it is more convincing. Anything that is subjective is less convincing. You are basically wanting to pile on as much as you can on your side of the scales of justice. You also want your evidence sources to have greater credibility and certainty. You need to understand who has the burden of proof on the specific issues. During the discovery process, you will see their evidence and understand how credible, objective, and the degree of certainty it has. This is why you need to understand the evidence process. More on this topic. Discovery is a process that requires each side of a legal dispute, upon a motion for discovery from the opposing party, disclose all evidence gathered to be used in a trial. That means, if there is a piece of damning evidence against you, you learn this before trial. There should not be surprises at a trial. There is an exception for rebuttal evidence that is usually intended for impeachment of a witness. The value of discovery is that you know the evidence that is against your case, and you can sift through it and put together the theme and specifics that you need to defend. There are timelines to the motions in discovery that are intended to create a speedy and fair trial process. It is important that you disclose all your evidence that you intend to use at trial, because hiding it until trial then opens the door to objections, preventing you from introducing the evidence. Before disclosing evidence and deciding to use it at trial, consider objectively if there is a manner the evidence could be detrimental to your case. Audio recordings, for example, can easily be a double-edged sword. An example of this known to me is when a mom was trying to prove that dad should have less time with the children, but she offered emails between herself and the dad's mother showing how well she communicated. What she was communicating about in the emails was that she kept dropping the kids off with the paternal grandparent and was spending less time with the child than dad was. The lesson is that although you see evidence proving a specific point like amicable communication, you could be showing your case is unfounded. Bring all your evidence to trial just in case you need to use it. A winning strategy in the movies as well in real life is to bury the crucial evidence you are using in a mountain of benign documents. The theme of the case is disguised, and the surprise that should not happen in a trial will happen organically. Discovery is fantastic when it is small. Large disclosures require enormous preparation if done properly. You can use this strategy, and it can also be used against you. Going through all the evidence looking for inconsistencies or even possibly perceived inconsistencies is critical. Your credibility is important, and if there is a misunderstanding that makes you look less than honest, can destroy your entire case. Understanding how to lay a foundation for your evidence is so very important, especially if you are pro se. A general definition of foundation is sufficient preliminary evidence of the authenticity and relevance for the admission of material evidence in the form of exhibits or testimony of witnesses. Laying the foundation for evidence is the process of authenticating the evidence to show the court it is relevant and not random made-up nonsense. Extreme authentication that can include submitting your own recordings for a forensic analysis to ensure an audio recording has not been tampered with can be referred to as polishing. If your witness chooses not to cooperate, it may be impossible to lay a foundation and admit important evidence. That is part of the trial experience. This is why you only go to trial when other options do not exist. The process of laying a foundation follows. 1. Present the evidence to the opposing party. They will be familiar with it because it was in the discovery they received. 2. Request permission to approach, and the judge will indicate for either a bailiff to offer exchange or you will approach and deliver the evidence. 1 to the witness, 1 for the judge, and then you already offered 1 to the opposing side. 3. Tell the witness they have been handed exhibit, whatever the exhibit is named. 4. Ask the witness to look at it. Do they recognize it? Please describe to the court what it is. Did you take this picture? make this recording, etc. 5. Ask the witness if the evidence is an accurate portrayal of events. 6. You can also ask them how and when they came about the evidence, and if there is anything in the picture, recording, or document that is not accurate. 7. After you offer the court your foundation, you ask the court to admit the item into evidence. Difficulty in introducing evidence may have solutions outside the normal evidence route. Evidence rules for impeaching a witness differ and may allow your evidence in. Another manner of getting the evidence in front of the judge without admitting it as official evidence is to use it as foundation for other evidence. At least the judge may see it. Every ounce of influence should be used. There is an exception that enables items into evidence that normally would not be. It is to use what I call the normal course of business loophole. I refer to it negatively because I have seen it abused. It works like this. Some business, let's say a doctor's office, normally makes notes in the charts. They do this in the normal course of business. Let's say there is a note of a negative attribute about you somehow. The opposing side submits medical records that include this negative note about you. Any person described as office manager at the doctor's office can testify that these are authentic. That's it. You don't get to cross-examine the actual person who wrote the negative comment. This information encourages those that know this to look for this information and tread carefully and even befriend the members of the establishment. This is a tool to be used both ways. Good attorneys make this a known fact to their clients. They have people scouring these records for anything to use. Any attorney loves good evidence. They don't all have the resources required to scour all the possible sources of evidence, so they depend on the clients or dumb luck to present them a winning case. Remember not to bring any evidence or even hint about the existence of evidence that is detrimental to your case to your attorney unless necessary, while at the same time still informing him of the events the evidence could prove. He should ask if there is anything that could prove it and if the other side has access. You need to be aware of what the opposing side can access as well. They have the power to subpoena anything about you that has anything to do with your capacity as a parent and the child's environment. This can include bank statements, credit card statements, and even phone records. Some of this can be redacted, maybe because the information request should be specific as to what information they want to access. Collecting evidence. Acting swiftly and consistently to gather and preserve evidence prevents the opportunity for things to get lost or get covered up. Here is a list of activities to consider. 1. Start gathering evidence. 2. Create a relationship timeline. 3. Begin using a journal with regular dated entries. 4. Understand what family court judges look for. 5. Develop a strategy supported by evidence. 6. Use a quality flash drive recording device. Recording your kids is creepy. Recording your ex is very fashionable. Protecting yourself from false allegations, priceless. 7. Categorize evidence by the custody factors. Overlapping will occur. What are the custody factors? That's a great question. They vary in different jurisdictions. Here is a generalized list. They also can change over time with new legislation and Supreme Court precedents in any given jurisdiction. 1. Moral status of parents. 2. Mental health of parents. 3. Child's preference. 4. Ability of parents to stay informed about the child. 5. Time that a third party cares for child. 6. Stability in environments such as schools and friends. 7. Parental abilities for stability and routines. 8. The ability of each parent to ensure the child's environment is free of any substance abuse. 9. The ability for each parent to have a positive role in the child's life. 10. The parent's ability to cooperate and encourage contact with the other parent. 11. Prior or pending allegations of abuse or neglect. 12. The conflict between parents. When you categorize evidence by a set of factors relevant to your jurisdiction, it is easier to recognize a pattern and create a theme for your case. When you have actual evidence, you can review and act accordingly. When you are not organized, you see the case from a more emotional perspective. Remember that emotional facts are not facts. Hearsay and exceptions. Hearsay evidence is nothing other than the evidence offered by a witness about which they have no direct knowledge, but is based on what others said to them. Hearsay. Evidence applies to both oral testimony and written documents. When testimony is offered that is hearsay, an objection to that testimony is required by the opposing party, or it may become evidence in the trial. There are exceptions to this rule. Employing these exceptions accurately is a skill not all attorneys have. Thus, skill can prove invaluable when reviewing evidence and planning strategy. Here follows a list of exceptions for you to explore. Please remember that every jurisdiction defines their rules and procedures, and the judge decides if testimony is hearsay or could be an exception. 1. Excited. Utterances or spontaneous statements. This is an unplanned statement made by a person in response to a startling or shocking event falls under this category. In other words, the declarant must be under some kind of stress while making the statement. Examples: please help. So-and-so shot me. The testimony may become admissible if the witness had only heard the declarant's statement. 2. Present sense. Impressions. This exception is about a spontaneous statement that conveys what the declarant is experiencing in the moment that immediately precedes or succeeds a particular event. For example, A and B were chatting when they saw their neighbor D moving fast on a skateboard. B told A, "Look, D is really fast and careless." Within seconds, D collided with an elderly lady who suffered severe injuries. The testimony of A regarding B's statement falls under this category. The statement must be made within a few seconds or minutes, before or after the event in question. 3. Prior inconsistent statements. Communications made by a witness before the time he or she takes the stand to testify in an action that contradicts subsequent testimony given on the same exact facts. Prior inconsistent statements can typically be used only to impeach the trustworthiness of the witness's testimony. 4. Admissions. When a party to the case makes an out-of-the-court statement, thereby admitting his guilt or liability, such statement may be admitted as an exception to hearsay evidence. For example, if A makes a statement to B that, "The fault is mine. I should have been more careful while driving on that road," the accident could have been averted. If B, as a witness, offers this statement as evidence, it may be admitted, even though it is hearsay. 5. Former testimony. In some cases, a party may seek introduction of a past testimony from a previous proceeding, where the witness had testified under oath and was also cross-examined. If the witness is unavailable during the current proceeding, his past testimony may be admitted as an exception to the hearsay rule. 6. Dying declarations. An instance where the declarant will not be available to testify. Dying declarations are sometimes admitted as evidence. 7. Forfeiture by wrongdoing. Applied when a party to the case intentionally or wrongfully makes the declarant unavailable to testify. If hearsay evidence is admitted under this exception, the party claiming the exception must prove the wrongdoing of the other party. Recording audio and video. The laws vary by jurisdiction. Do not break the law. The laws regarding audio and video recording are different. Note the differences. Some of the biggest issues the laws concern themselves with are consent, one person's knowledge or two persons' consent. Must you be present to record? Or can you leave a recorder and come back for it? And on whose property can you record? There are many devices for recording. Covert recording is its own industry. I would recommend recording devices that use flash downloading. These can usually enable stamping with time and date. Sony makes some pocket audio recorders. You can download weekly and automatically and have these filed for easy lookup later. The best recordings are the ones where you say very little or nothing. Trying to get someone to say something is a bad strategy. Organic life is easy to read. Consistency is its own value. To never miss an event, a habit of recording is necessary. This habit is also a defense to an allegation that you instigated an event because you had a recorder on it. Always be aware that you are probably being recorded as well. Live that way. Think before you speak. If you have a valuable recording, email it to yourself, copy it on a jump drive, get a security box at a bank, and preserve it like it is gold. Imagine losing valuable information and spending $5,000 on a trial instead of an easy settlement due to leverage. That could be the difference. If you have a recording where the other party is misbehaving, don't trust your perspective about it. Your behavior on the recording could be foolish. If you find yourself foolish on a recording, I might delete it immediately before discovery is sent to you. Do this only if your jurisdiction would not find this action illegal. They will ask for all recordings and can subpoena your electronics. Some of this data can be retrieved after deletion. Be careful. The key is not to be at war, but an information gatherer, so that an understanding can be ascertained based on your evidence collection. This will help mitigate any false narrative the other side may entertain. Don't create a narrative. These are your children, and they deserve both parents. If they don't get that, do not be a part of that happening. Let the judge make those choices. If a false narrative is being created about you, you need to consider one-on-one consulting with us. When the other person is recording and trying to instigate conflict, be simple and inform them that you will communicate in an email after you have given it some consideration, and be polite. Why not be nice? If you are angry, get a counselor. Seriously, be nice. Make your children the center of consideration. If you feel threatened that you will lose your children, be nice. That stability and lack of conflict will translate into a parent that is a safe place to have children raised. You will likely be antagonized. Be nice and remember you are being recorded. When your conflict is in emails, remember to use our coaching program to help develop email reply options that not only de-escalate but will communicate your ideas in a very peaceful and reasonable way. There are times that any reasonable person will react in an unreasonable manner due to the ridiculousness of a situation. We can offer responses that will maintain focus and a calm demeanor because we are detached from the emotional content that drives the conflict. You will be collecting evidence in emails in your favor and avoid building evidence against your case for the other party. Do what you can to control the evidence. If you know that the other party is not following court orders or is breaking the law or doing anything detrimental to your children, consider the use of a private investigator. Their craft is useful to collect evidence that it may be wrong for you to collect. It is wrong for you to track your ex-partner. You would be considered a stalker. The PI will document in a manner the court will appreciate as evidence that would be admitted. There is, of course, a cost to this. Compare the cost of this valuable evidence compared to the cost of a trial and expert witnesses from the mental health industry. If you find the strongest evidence in the most efficient manner, it is a win-win. Best of luck. This is the end of the evidence module.